Welcome to Case by Case. This is a podcast brought to you by Floyd Zadkovich. This is Calum Cheyne. I'm Logix Zadkovich.
Every episode, we read a case independently of each other. We jump on the podcast, we hit record. So what you get is our raw thoughts on that law.
And we're super excited with some of the guests we've got coming up on future episodes. So keep an eye out.
And if you like the podcast, all we'd ask is that you hit subscribe and share with your network. Okay, let's get into it.
Let's do it.
Welcome to Case by Case. This is a podcast brought to you by Calum Cheyne.
Hello, everybody.
And Logix Zadkovich, that's me. And today we've got with us Matthew McGhee from 20 Essex. Matt, how are you?
Very well, thanks. Thanks very much for having me back again. I made the cut last time, clearly.
Yeah.
Back on.
I don't think we've had many repeat attendees. Maybe Phil's been on a couple of times.
We've had
of our associates.
Yeah, internal repeat guests, but I think you're maybe the first external repeat guest. I feel very honoured. It's a pleasure to be back. Thank you very much.
Super exciting. And we've got one of your kind of pet projects to talk about here, all about kind of fraud, and it's like a weird intro, isn't it? This is one of your pet projects, a case about fraud, right? But for lawyers, this is how we talk to each other.
But I think actually it's not all that far removed either from what we talked about last time when I was here, which was all of this sort of payment type fraud and essentially who's responsible when the fraudster runs off with the money.
Yeah, exactly. And yeah, look, today we've got one where you've got a fraudster who's managed to insert themselves between two parties and then pretend to be one party to the other and vice versa, and then kind of take off with the money. But before we get into that, what's been keeping you busy, Matt?
Well, once I'm sort of free of various work things, it's finally summertime has landed in London with a bit of a bang. So I'm taking a step into your world, Luke, and taking my first dabbling toes into triathlon.
Oh, wow. Okay. Well, that's cool. Yeah, we know a bit about triathlons, don't we, Calum? I don't know if we've told our audience on Case by Case, but Calum and I have signed up to do a full Ironman in August, which I don't know about you, but is coming around very, very quickly.
It is so much sooner than it was when we booked. It keeps getting sooner and sooner, actually, and we know a little bit about triathlon, but not nearly as much as hopefully I will know in 6 to 8 weeks' time when I'm at the start line. And hopefully at the finish line.
Hopefully at the finish line, yeah.
Come in very quickly and say that my experience is on a much smaller scale than yours. So, yes.
So what distance did you do?
I did the Olympic, which is about a quarter Ironman. So you just have to do it 3 more times after that.
Exactly. Yeah, exactly.
How did it feel?
Look, that's a very sensible place to start. Is this your first?
Yeah.
You haven't done a triathlon at all before, have you?
No. Actually yesterday I did technically do similar distances to an Olympic triathlon as part of training, but it wasn't a proper event. There's an event not far from where I live in a couple of weeks' time, which is a half Iron, and I'm thinking I might just roll along to that and see how that goes.
Yeah,
I think I could do with the confidence, to be honest, of actually getting through something.
Right.
And it's always helpful to be in these events. I've done running events. Did a marathon earlier in the year, and I've done cycling events, a number of cycling events over the course of my life. But I've never actually had to join them up, do the transition zones, and make sure everything's in the right place.
Yeah, well, my challenge is not to have an accident right before the race, like I did the first time I did one of these. So I haven't done a full Ironman, but I did do a half Ironman in February last year, and 3 weeks before the race managed to come off my bike. So that's kind of my number one priority, is to actually get to the start line in decent shape. And then the second priority is just to finish the thing. If I get to the end and I'm half jogging, then I think I'll be pretty happy with myself.
For me, it's get to the end of the swim. Once the swim is done, then you can just relax and enjoy the bike ride and enjoy the run. But far from being kind of Australian and all the natural swimming genes that you get from being Australian, I have my sluggish Scottish approach in the water, and I'm finding it difficult to shake that.
Well, I think that's the same with you. You're a cyclist runner more so than a swimmer, Matt.
Yeah, the swimming definitely came in at that very much third place of those 3 sports for me. So we survived the swim and then made up for lost time elsewhere.
Yeah. Well, look, I dare say you might hear some more about the training Calum and I have ahead of us over the next couple of months. But today, should we get into this case? Should we hand over to the expert to give us a bit of a rundown on the facts, Matt?
We should, but it wouldn't be right to not have the case note.
Well, thank you for the... actually, you know what? You should do it. You remembered, so you can do it.
I'll do the names, but I'll leave you to do the citation for our citation fans.
Okay.
Okay, so this is a case in the High Court of Justice, King's Bench Division, between Logix Aero Ireland Ltd and Siam Aero Repair Company Ltd.
Okay, good. And it is relatively recent, actually. 23rd of May, 2025. We're in the High Court. The neutral citation number is 2025 EWHC 1283KB, as Calum says, for our citation lovers out there. And it's a decision of the Honourable Mrs. Justice Heather Williams, DBE. Matt, should we give a bit of a rundown of the facts of this one?
Yeah, absolutely. And it's a factual scenario that comes up time and time again in all sorts of industries. And it arises from the fact that we're still using sort of slightly archaic methods to deal with pretty momentous contract negotiations, conclusions, and then invoices. Because everything is just done with unsecured PDFs sent by standard email messages. But what happens is you have the seller and the buyer of these particular engines enter into a letter of intent with one another. It's got a confidentiality term and a few other sort of boilerplate type provisions saying we're interested in concluding a contract to sell a couple of engines. Thereafter, they start to negotiate this via email. But as you said in your intro, Luke, along the way, by means which are still a bit of a mystery, it's not in the judgment. Somehow a fraudster finds out about this email chain, gets a copy from somewhere, and then engages in quite a creative exercise of setting up similar domains to the genuine domains, and then corresponding with Siam pretending to be Logix, and corresponding with Logix pretending to be Siam, with neither of the parties actually knowing that they're talking to the fraudster the whole time. So he adapts the communications that are coming down from one side, changes the bank details, changes payment terms, and then passes them on to the other. What ends up happening is that the two parties both separately sign slightly different versions of the same contract, and then an invoice is produced and is then paid, and it's only some days or weeks after that that they realise what happened. So in the meantime, the fraudsters run off with the money and the two parties are left trying to pick up the pieces and work out who's got to pay. It's
a pretty well executed fraud because the fraudster gets involved. And as you say, the domains are very similar. So you have these, they basically take our email addresses, for example, are @floydzad.com. And it would be like someone jumps in and says, suddenly you're receiving emails from @floydzad.co. You'd imagine that between the parties, it probably looks as though they're still corresponding with, it looks very much as though they're still corresponding with each other. But in fact, this fraudster has managed to kind of insert themselves and separate the lines of communication. So they're controlling everything and ultimately receiving payment.
Well, it's something that I know as a business talk a lot about in, warning staff and what have you, that don't just accept the name that pops up. In Outlook, how you just get someone's name and then underneath it there's a Gmail or something like that. Now, if you hover above the name, it's very obvious in those cases that it's not a legitimate email address. Here, you can see how it's easier to be fooled by, and the email addresses are set out in the judgment. They are very similar. But that's how the fraudsters pulled it off. It is interesting, though, and we'll get into some of the law in a minute, but just talking about these types of cases, we've seen these often arise in the broker context, and I did wonder about that in this case, whether the weak link in the chain, without naming anyone, but was the third-party broker that had access to this, because that is often a way that the fraudsters go in, rather than try and break through the security in place for big corporates, like may have been involved here. The one-person band type set up with a broker can sometimes be the way that the fraudsters get in and get access. Have you seen that quite a bit? Or?
Yes, that or sometimes if there is a broker who is exchanging all the messages in between, then you have this sort of setup, but between, or the fraudster coming in between the broker and one of the parties.
Yes.
Where you have even more sympathy then for the other party, because they are genuinely receiving messages from the broker saying, charterers have told me this, or owners have told me to pay this account. So it's I think sometimes you have to take a step back and think, well, just thinking about it, not legally for a minute, but just on a commercial level, what could the parties do to stop this sort of fraud? As you said, check the email address, where you're receiving the emails from, and who is able to guard against it, who's in the best position to stop this happening. And if ultimately you can follow all the best practices and still fall foul of it, maybe that's a commercial reason at least why the onus on the other side to explain why they shouldn't be responsible.
Well, my thinking on that was one of the points I was going to kind of come on to at the end, but I'm happy to talk about now, is I would have thought through some contractual language, you could make very clear what is the email address you are going to use and only use in performance of this contract, unless there's express written notice otherwise that we've changed our email account. And if you do that, you're really putting it on the other side in a way, to say, look, if you get something that's not from this email address, it's uncontractual. And both parties could do that, and at least it kind of puts the onus onto someone who receives an email from a similar.
At least to say that this is a new email account. How do I take it as? I suppose the issue then is he's sending an email to the fraudster saying, "Hey, you've sent me this from a new email account. Can I rely on it?" And the fraudster says, "Yeah, of course."
I've actually got a case on that. Exactly, that happened. There we go. We asked that question, and the fraudster said yes, and we were totally reasonable. So it does happen. But here, that all presupposes that you identify that there's been a change in the email address. And actually, one of the issues here is the email address was so similar that actually even after issue, one of the parties didn't really clock what had happened. Right. I think that shows here that it was, as you say, a very sophisticated implementation of fraud.
And probably somebody there's someone who's in the know that's actually perpetrating the fraud. And one of the kind of curiosities of this case is, as you say, we don't know what actually happened there, but it feels like there's enough internal knowledge that there's somebody within the circle who may have, or either that or it's a very clever fraud and someone's been able to insert themselves into the circle to find out the information. But you can see the frustration on the side of the defrauded party, because they probably feel like there's an explanation somewhere or an investigation somewhere that they've not got an answer to, that they want an answer to.
And I think that's a good segue to get into some of the aftermath about what happened immediately upon discovery of this, in that one of the parties came out blaming the other, right? And even included in their particulars of claim, when they brought the claim, allegations of, not allegations of fraud perhaps, but, indicia of fraud.
I think the judge was very impressed. It wasn't far off an allegation of fraud.
Right, exactly. So I don't know if you want to pick it up from there, Matt.
Yes. I mean, so there's obviously the legal stuff about who's responsible in this sort of scenario. But then before we get into those, actually, this was a big feature of this case, that the judge was pretty condemning in some ways of the drafting of the original claim. Yeah. So as you said, Luke, they didn't plead fraud, and counsel who appeared for the claim to this case, who was different counsel who settled the pleadings. The judgment doesn't actually say who did settle the pleadings, perhaps to spare some blushes, because new counsel said, well, look, here are some reasons why it was pleaded in the way it was. We wanted to put all of our cards on the table and say, here are some questions that we had. The problem is that it's common in a sort of a style of advocacy, but also any sort of advocacy, political language, to raise questions or say, well, I'm not making any accusations. I'm just saying that there are some things that need to be investigated here. But making those sorts of suggestions inevitably carry with them an accusation. So if I say, well, I'm not making any allegations, but there were some biscuits in here earlier. I left the room and Luke was here on his own and there weren't any biscuits left by the time I got back. I'm not suggesting that Luke ate the biscuits. But that's all over his face. That is essentially what's being said. And
how do you guys know my weakness for biscuits?
What the judge said is actually taking that approach with, as you say, indicia of fraud is improper. It's not just inadequate to plead fraud, but it is actually improper as a matter of pleading practice. Yeah. So in this case, despite the explanations that were then given as to why it was done, including that there was time pressure because there was a foreign court set of proceedings which was said to be imposing a particular deadline on issuing this claim. The judge here said it was inappropriate to include those indicia of fraud if they're not being followed through to an allegation of fraud. And because of that, unusually she ordered indemnity costs, but unusually she also invited submissions on that at the start of the hearing, not waiting until the outcome of the application, saying, well, and now we're dealing with costs generally, we'll also touch on this question. Mm-hmm. So it's clearly a point that did exercise the judge.
Well, maybe worth just pausing there to look at what this is actually a judgment for, because this isn't a kind of judgment at the end of a long process. This is a strikeout application, or alternatively a reverse summary judgment application. Two slightly different things, but both going to the same point in principle, which is this claim should be thrown out at a very early stage. So this is why perhaps we get into questions of indemnity costs so early, and also why we're looking, so closely in this case at the way it's been pleaded and potential deficiencies in the pleading.
But also as I say, the fraud-like allegations that were in there, they weren't advanced, like they weren't progressed at the summary judgment hearing, so they had kind of fallen away, and that's why I think the judge thought that, well, let's hear costs as well and deal with that at this stage, because it's not something that's going to turn on the decision on the merits of this particular action. I think the other factor here that may have come into it is that the nature of the arrest that was obtained. So basically payment was made by the buyer, and the two engines, these Aero engines, were in France, I think it was, and the buyer wanted to freeze them. And so went and got a seizure order of the engines. That it seemed like the basis of that seizure was some kind of elevated allegation like fraud. I'm not sure if it was exactly fraud, but something like that. And so then brought the substantive action in England with similar type allegations to prop up the attachment, when actually there wasn't the evidence for that to bring in the first place. And acting, well, in fairness, acting with speed and all that, you can see how these things happen. But you've got to, even when you're doing things quickly and moving fast, you have to think a few steps ahead, and you can't just throw spaghetti at the wall and hope it sticks down the track, especially when you're pleading things like fraud.
Yeah, you can see the approach, right? They want physical control of these goods, and the way they get there is by this application in France, which probably for French law reasons, they probably have to advance these kinds of allegations. And then the French court says, well, you need to go and start the English claim. And then to start the English claim, they have to bring these, they make what seem to be similar allegations. And then the response, which seems to be quite a good one, is to say, well, the way you pleaded the case in the English proceedings is improper by English standards, or alternatively is subject to reverse summary judgment. And that brings us to the application.
Yeah, and I think I agree absolutely with what Luke said, in the sense that you have to do things properly. You can't just use the excuse of moving fast as an excuse for doing things improperly. But what you can see in this case is a very much an evolution of the claimant's understanding of what actually factually happened, and therefore legally what their case is. So they started out with potential allegations of fraud. They seemed to think that the seller was actually in on it somehow. Then they rode back from that a little bit. They advanced one case, they amended, moved to something else. Now, the judge did say one way in which you could have not put yourself in this hole would be to have issued the claim in England within the deadline set by the French court, but then to have essentially tried to stand still for a little bit, not immediately serve particulars of claim, serve the claim form, but just do the bare minimum, issue the claim, and then engage in a bit of a discussion with the other side.
Yeah.
I can see a lot of sense in that. Obviously, what the judge says makes sense and would be a solution that would have avoided some of these problems. But I can equally see that a claimant who is being pushed to proceed might well not feel that that's really an option. And it also then shows you have this difficulty when you're dealing with actions in two different jurisdictions. It's all well and good in England to say, well, we have issued the claim because we have paid the court fee and we've got a bit of paper now. But a French court might say, well, no, that's not really issuing the claim in the way that we meant. You actually need to progress the claim within the month. So there's a bit more of a room for perhaps an allowance for the claimants on that side.
Matt, should we go through the legal framework for strikeout and summary judgment? So, what are the thresholds and the tests that the court's dealing with here at this stage?
And these are very well established now in English law, and this case doesn't advance them or change them in any way. So, as you said, Calum, essentially there's two ways of looking at a very similar question. And really what the court is asking is whether there is a real prospect of success. So it's looking at a very low bar. If your case is more than merely fanciful, you're going to clear it. So what is notable here is that the judge did strike out or give summary judgment on these claims. He said, no, there are two arguments you've tried to run. Neither of them have any real prospect, so the case is not going to go any further. And obviously, huge cost saving for the other side. And I think then the only other points to add in at this stage about the test for strikeout summary judgment is there are previous judgments suggesting the court should be particularly cautious about taking these steps if factual investigation is needed, or if you're dealing with a novel area of law where actually it is best to have a novel area of law determined on actual facts rather than assumed facts. So the judge took account of those matters and still said, no, this claim is not going anywhere, so I'm going to strike it out at this stage. And that's probably a nice way to jump on and say what the two claims are that she did strike out. But before that, there was a brief bit in the judgment where there was a reference to claims that were previously advanced and then dropped even before this stage. And they were allegations that, as a matter of implied contractual terms, or in essentially the tort of negligence, it seems, the seller owed a duty of care to ensure they had adequate cybersecurity. And this case shows, well, that wasn't even attempted before the judge. And there have been a couple of cases in the last few years where the High Court has essentially said, you're not going to get off the ground, absent some sort of special facts on those sorts of claims.
Right.
So what we're seeing is ever-increasing creative ways of people trying to come around that. And here, those two creative ways are first to say that the fraudster had apparent authority, and alternatively to look at the confidentiality term in the LOI and say there was a breach of that term and that's what caused the loss.
Yeah.
You can see how it's a stretch from the apparent authority test to try and say that a fraudster who has kind of borrowed parts of an email domain to insert themselves into email exchanges has apparent authority. But yeah, I guess it's an interesting lens through it to review apparent authority and to take a look at that law again.
Yes, and it all essentially revolves around the question of whether the individual who said have apparent authority, even if they didn't have actual authority, was put in a position by the person they professed to be acting by, such that it was essentially fair for anyone else to rely on that. And what the judge said here was, well, you didn't realise you were dealing with anybody else. You thought you were dealing with your counterparty. It turns out you were dealing with somebody different, pretending to be the counterparty, but you can't possibly turn around and say that the counterparty put the fraudster in that position. As I said, it's a very difficult argument in this case, because again, going back to what I said earlier about the sort of commercial sense of it all, from a commercial point of view, either party could have realised what was going on by noticing different email addresses, but neither of them did. So it's not a case where you've got somebody who is sitting inside a genuine email server sending out fraudulent emails. Then it's, I think, a different question.
Yeah,
very true. Yeah.
I think there's also, bound up in apparent authority, there's also that concept of representation by the principal. And clearly the principal here is not represented that the fraudster is an agent of the principal. And I think that's, when thinking about ostensible apparent authority, that's one of those key aspects of it, which is clearly missing here.
Is the idea that the agent would be able to self-authorize and say, I am acting as I am an agent, take it on my word, I have apparent authority, is something that you just can't really do as an agent under English law. And if you're a fraudster, then almost by necessity, you would have to do that. And in a way, if the fraudster did have apparent authority in this sort of circumstance, it would open up apparent authority to such a huge category of potential agents, because you could just say, I am acting as an agent. I now inform you that I'm acting as an agent on behalf of Matt. go ahead and represent Matt. It simply doesn't make sense.
Exactly. Like, take it off email for a moment. It'd be like someone knocking on the door with a business card that they've mocked up themselves. It's similar to the principal's business card, and they just say, here you go. I'm, the agent of this company. Do a deal with me, right? You can't self-authorize yourself to be someone's agent. So that's this concept of representation, which clearly was missing here.
And then moving on to the confidentiality clause, which is quite, the confidentiality clause is quite an interesting one, because there are still unknown facts, and it strikes me that it's not impossible that there was a breach of the confidentiality clause. It's just there's no kind of factual basis to allege at this stage that there were, which is a curious position. I suppose maybe this is where the decision is at its most interesting from a summary judgment perspective or reverse summary judgment perspective. And the kind of, I suppose there may have been some temptation from the judge to say, well, let's play it through. Let's have some disclosure. Let's see what's in the systems. Let's see if we can find anything that might give credence to this alleged breach of the confidentiality clause. Because I suppose, in fairness to the claimants, they simply cannot know what is going on in that server of the defendants, and it's very difficult, I suppose, it's very difficult to advance an allegation of fraud, or suggestions that there might be some fraudulent type conduct, or suggestions that there might have been some kind of some failings on the part of the defendant with respect to confidentiality. Because they simply don't know what's happened on the defendant's side. But it did strike me that this alleged breach of the confidentiality clause was perhaps the one that would have given the judge slightly more difficulty in striking it out at such an early stage.
Yeah, and I like you, Calum, I thought this was the more interesting part of this decision. I hadn't seen a confidentiality clause argument like this progress, not at least in a judgment. You may well have before, Matt. I don't know, have you come across the argument?
No, that this is, I think, a relatively new development. As I said, people are looking for ever more creative ways. And I think the key thing is that this confidentiality clause isn't in any way unusual. It's the sort of boilerplate confidentiality clause that gets plugged into all sorts of contracts.
Yeah, and I was actually just going to read the clause out. So this clause sits in the letter of intent that was signed by both parties. There was a clause in the LOI that said that this clause, or at least this and other clauses, were legally binding immediately. So there's no kind of debate about whether the clause itself was binding or not, but it said, seller and buyer acknowledge and agree, A, that this LOI contains commercially sensitive information, B, to maintain any information and documentation provided hereunder on a strictly confidential basis, C, that it will not disclose such information and documentation to any third party other than board of directors, auditors, shareholders, etc., or as necessary to comply with law. Words to that effect on the back end there. But there was actually quite a bit of a debate about what this clause, what type of information this clause was intended to cover. Is it only intended to cover commercially sensitive information as referred to in A, such that the prevention of disclosure relates to that type of information, or do you look at B, where it's a kind of broader type of information documentation, where it says to maintain any information and documentation provided hereunder, so under the LOI, and that it's that broader type of information that is confidential and not to be disclosed. And the court ultimately ruled that didn't make a difference in this case, but did I think have some went along with the argument that it is actually the broader of those two definitions that the confidentiality clause intended to apply here. Absolutely, and I think it seems from the judgment that there was quite a lot of argument about exactly what this clause meant and how it might or might not be engaged. And counsel for the defendant, who were advancing the application and trying to strike the claim out, clearly had a number of points where they said, well, for this reason or that reason or another, you can strike it out at this stage and say the claim doesn't go anywhere. And it is very interesting that the judge said, no,
I want to let this proceed to trial, ignoring the other factors we're going to come into, because there are arguments here. And the judge, it gave some indications one way or the other that maybe this bit looks a little bit weaker or that argument is not going to work. But there was enough in there to certainly survive the strikeout challenge. So I think everyone should be looking at their boilerplate confidentiality clause and saying, does this mean what I intend it to mean? What are the perhaps unforeseen consequences of having it in there?
I think that's right, because I must admit I wasn't attracted to the argument that it's narrow in the sense that there's like some underlying purpose to the clause. That it seemed like it was a bit of a stretch to me. Sure, it needs to fit within the definition of the type of information, but what consequences may then flow from the disclosure of confidential information? The clause doesn't speak to that, right? And so I can see if, as a matter of causation, there was some damage or losses suffered as a result of the disclosure of the confidential information, then I don't think it necessarily follows that, that there's a kind of narrow purpose to the clause, if you know what I mean. I don't know what you made of that. But.
No, I agree. And I think the courts don't like being told, well, here is a very broad clause, but obviously the purpose, the unspoken purpose behind this was to cover this sort of scenario, not to apply here.
Yeah.
Well, if you've written a contract and the words are clear, you haven't got any room beyond applying to rectify the contract to go behind the words. So if the words are so broad, they are going to be engaged in this scenario. That's the contract you entered into, even if you didn't realise it at the time.
But also, is this not one of the reasons why you would want things to be kept confidential? You know, clearly there's been, or it appears as though there's been some kind of leak that's allowed somebody to understand the basis of the transaction, insert themselves in, and take the benefit of the transaction. As in take the money that should have been transferred to the seller. That strikes me as kind of the sort of thing that you would want to protect yourself from by including a confidentiality clause. We don't want anyone outside the circle of trust knowing what's going on here, because yes, they may share confidential information that could be commercially significant with traders or kind of competitors that might be used in a way which is, you know, maybe commercially beneficial to other people outside of our commercial interests. But also, this information could be used in a way which is, used by somebody in a thoroughly illegal way that deprives them of benefit. Like to me, this is actually fairly squarely one of the reasons why you would want to protect confidentiality.
Yeah, and I think it's a good point that Matt makes, that commercial parties really should look at their clauses like this, and these boilerplate clauses which you don't give much thought about when concluding a contract, because that's my take too. I actually would be quite comfortable making that argument, particularly if the facts were slightly different and only one party really contributed to the loss and it sat on their side. They were the ones that a fraudster maybe got into their systems and what have you. If the actual underlying fraud sat more on one side, then I could kind of see this argument actually stacking up, that actually you had a contractual duty to keep the information private and you didn't. So not the facts here. And when I first read the argument in this judgment, I did think, well, hang on, what about causation? Like, that was the first thing that jumped out to me. And that, if both parties are misled and both parties have, fallen prey of the fraudster, then has the loss suffered here been caused by the breach of the confidentiality clause?
Yeah, clearly you're destined for the bench, because that was then the point which
I don't know
picked up on. But that's the reason why the judge said that even if there's these construction arguments which I'm not happy just disposing with at this summary level, if there is something in them, there is nevertheless a serious problem with causation. And it all comes down to whether the breach enabled the fraudster to carry on. And there's perhaps a room for a little discussion here, because the judge said, no, that the breaches as alleged did not enable the fraud, because what enabled the fraud was both parties engaging to an equal degree in correspondence unwittingly with the fraudster. And on that basis, the claim collapses. You can't just say, because one party allowed the fraudster to have access to this particular bit of information, then that meant that the whole fraud followed from there, because it didn't. It only would have followed through if the other party was also engaging in providing information by return, hence the exchange of contracts, the invoices and payment details. What it does highlight, though, is if it is the case of, or if it were to be a case where you can identify where the breach came from,
Yes.
who was responsible for the fraudster getting the information in the first place, I just toy with the idea, well, what if it was the sellers who had printed out an email and it thrown out the window? Because that's all you need, and it's your point, Calum, that actually it's not about sensitive commercial information. If you have an email from an email chain, you know who is corresponding about this particular project, that there is some correspondence to follow up. All the fraudster needs to do is send a follow-up email saying, shall I move this forwards? And then everything unravels from there.
Yeah.
So
laptop left on the bus, or any of that kind of scenario where there could be some way that information's got out. And coming back to, it's so easy when we do this regularly on the podcast, and some people must just roll their eyes when we start talking about, the benefit of hindsight and looking back, right? Especially from a practitioner's perspective. But you can just see how this has played out. They wanted to get hold of the engines, get physical seizure of the engines, understandably so, right? We would all in the same position be wanting to make sure those engines are tied up if we can. Probably to get a French arrest, they needed to allege fraud. And then they've been on a tight deadline to do it. They then come to the English court and pleaded fraud-like allegations. And it's gone down this kind of path, okay? If, however, at the outset of this case, and look, there were investigations, there was an exchange of IT reports and what have you, so it's not like they didn't do anything at all. But if more time had been allowed to elapse and there'd be more attention on causation and really making out this claim, say, well, look, if this claim is going to stick in any way, it's going to be through having something we can point to on their side, on the seller's side, where they've contributed to this loss that gets us home on causation. So if the approach initially had been more around, well, let's get into disclosure. What do we have to do to get this claim through a summary judgment, strikeout type threshold and get into disclosure past the causation test? And I'm not saying they would have been able to. It seems really unclear what actually happened here. But that's curious, because in a lot of these cases, eventually there is some illumination of what happened. And I just wonder, if the focus had been more on that for a longer period of time, and even then using some of the tools that courts have to order handing up of hard drives, or, so maybe disclosure in a different jurisdiction or what have you in aid of these proceedings, perhaps there might have been something there that you can kind of cling to, which is more culpable than they had. I don't know. It's just a thought I had as I read it.
And I think it's a sort of the flip side of the coin, that what you can see from this is the way that the case has panned out has been led very much by those initial steps.
Yeah, exactly.
It's inevitably the way things just take on a life of their own and do go in a certain direction. And what definitely was a bit of a turning point in this case was when they did finally get some discussion of the other side, only after the claim was issued, and essentially pretty much as the time the summary judgment application was being sought, that suddenly the factual situation shifts, and they're then faced with a different case. They then need to try and plead a new case.
Yeah.
It is perhaps a lesson in, as you said, having that little bit more time, or at least trying to buy that time as much as possible, and entering into a discussion with the other side if you can. And now the issue here is we all as litigators are in this position of tension. You don't want to go to the other side until you think you've got all the answers and you're in the strongest position possible. But if you wait too long and things get too acrimonious, you then might be met with sort of resistance or suspicion, and you're not going to get that sort of bit of factual progress that might allow you to perhaps get an easier way through.
It's, as you say, like, it's difficult, and it's all hindsight. But there is a sense that the tail starts to wag the dog at some point in the procedural history of this one, where, like you say, they've gone to get the thing. Get the physical control over the asset, and they then have to just unwind the consequences of it over a long period of time.
And that's when you can see by the time it gets to this kind of stage, you've got a judge looking quite critically at it.
Yeah.
Like, you know what I mean? I could see how this case, maybe I'm wrong. Okay, this is just pure personal opinion here. Could have got to this stage with a bit of, reshaping of the position and just gone at it as it ended up here with something a bit more convincing on causation to get through this phase. I'm not saying we would have won a trial, but it might have got through this phase.
Because the causation point feels unfair. It feels a little bit unfair. I take the point, and I understand that the judge compares the judge looks at the causation point through the lens of the pleaded case, which obviously she has to do, and she finds that this confidentiality clause broadly, there's no factual basis for the claim. But just again, stepping back in principle, the idea that engaging with the fraudster breaks the chain of causation as a really broad principle. I don't think the judge is quite saying that, but that does strike me as a slight leap, and maybe something that at least could have been tested at a hearing. But obviously, like I say, and as you're saying, like the judge is looking at this very critically, looking at it through a lens where this isn't just an on-paper issue which is being pleaded out in the English court. There's also proceedings in France going on. There's also goods have been detained. There's a lot of water under the bridge, and I think the judge is kind of making the point that you have to do slightly better once you get to that stage, just in the global in the global case, and maybe have a few more answers.
Did you have any other points on the confidentiality clause, Matt, that you wanted to talk about? Like, I think, yeah. I think ultimately the judge is looking at this as a fraudster stepping in and fooling both parties. And, that's lists a number of ways in which both parties were misled by the fraudster, rather than it kind of falling on one side or the other.
But I think two final parting observations. First is that it is very difficult to really answer the confidentiality question when there isn't any answer as to where the original breach came from. That, I think, is the key question that's missing. The other aspect, and this is, again, think about your boilerplates, is whether there should be some qualification in the confidentiality provision. Because as framed, it is absolute. You shall keep confidential, you shall not disclose. Now, shall not disclose is quite easy with a thought, don't go and tell anyone. But disclosure was argued to be a bit broader than a positive divulging of information. So query whether you might want not to subject yourself to an absolute obligation of confidentiality, but instead shall take reasonable care to ensure confidentiality, because that should cover most instances. And you might then have an argument about, well, did you exercise reasonable care if you allowed a fraudster to get access to this information? But you're not setting yourself up to a hostage for fortune if you acted with all proper reasonable care, but nevertheless you were responsible for a breach. And then that is going to snowball and cause you a big problem later on.
Yeah, I think it's a good point. I do think, in these types of cases, we often come away with kind of drafting points on contractual clauses that we may not have thought of before. But at the same time, I still kind of have sympathy for the argument that, you are responsible for protecting the confidentiality of the contract. And it's not just for trade secret type commercial reasons. It could be for any type of reason. And as drafted, I don't think there's a limit on purpose here in this particular clause, but you could see that could be written in. You could have a clause that relates to that. Interesting. Yeah. So any other thoughts from you, Calum?
Maybe just briefly to touch on indemnity costs.
Oh, yeah.
For, I guess to go right back to basics for our international listeners or kind of non-legally trained listeners. If you win a case in England, then the normal position is you get your costs. And normally that's on what's called the standard basis. If you win spectacularly, or if there are other kind of compelling factors, then you can get your costs on the indemnity basis. And the indemnity basis is usually is always a higher level. It means you cover more of your costs. There's less of a discount applied. And that this came up in this case, as Matt said earlier, because slightly unusually, the judge engaged with the question of indemnity costs as part of the substantive hearing, rather than as a kind of consequential hearing. And in this case, in fact, awarded indemnity costs to the defendant.
Yeah, and what I would say on that is it's also a bit of an illustration as to why even a very successful party isn't coming away with a total success. So here the defendant seller has struck out the whole claim. They were successful in getting rid of the whole proceedings without disclosure, without trial, without all of the extra cost that comes with that. And yes, there was an order for indemnity costs, but I'll come back to that point in a second actually. But even on an indemnity cost assessment, you're not going to get, or you're very unlikely to get everything. So the seller party is still going to be left with a situation where they have paid out money to the lawyers that they don't get back and they can never get back from anybody.
And it'll be a smaller percentage because it's an indemnity cost level than a standard cost level, but these things can be expensive. And lawyers are typically quite expensive people to hire. So there is that small percentage can be quite a lot. As you say, Matt, in this case, also the indemnity costs only actually covered the initial claim, particulars of claim, subject to whatever was decided in the consequentials hearing.
Yes, so on that I did actually do my homework, and
well
on the court docket there was an order last week for costs on the standard basis. So the seller parties have got all of their costs of the proceedings. They got a little bit on the indemnity basis in respect of the pleading, which was improper on the judge's view, but then the rest of it is just on the standard basis. And there's cases saying don't give percentages because there is no rule of thumb. Everything is case by case. But as a very rough approximation, a standard basis, you tend to get 60, 70% of your costs. Indemnity, you might start to look at 80 or so %. But there's still a substantial chunk that you're not recovering.
And presumably in this case, they therefore would have recovered standard costs on the question of arguing over indemnity costs.
Quite probably, yeah, quite probably.
Which is the sort of thing that doesn't make lawyers very popular.
Well, there we go. It's good to do this in person. Huh?
It's nice.
Yeah. It's really good. We don't get to do it all that often with our guests as well. So thanks for coming into the office, Matt.
It's a pleasure.
It's been good kicking around another one of these kind of email fraud type payment cases with you. Next time we're going to have to get him to do something else, surely.
I promise we'll do more traditional shipping next.
I'm just joking. But thanks again. And thank you everyone for listening in. Hope you found this of some interest, and there's a few takeaways for contracting moving forward. And look, all I can say, and I say it a bit in the firm to our business, just be vigilant on emails. Like, it's so easy for this type of fraud to happen, and a lot of it can be avoided through very close scrutiny of emails. I wondered whether, and I know there's all sorts of technological ways of getting around this, using better systems and all the rest of it, but look, we're stuck with email for now, I think, for the foreseeable. I wondered whether they should just get rid of the ability to show the name on emails. Show only the name without the email address when it pops up. Like, I would have thought that, and maybe there's a setting on there where you can make it insist on showing the email address as well, because that would, your mind can trigger to these things if you see it. Because you'll see them stacked up in your email account. It'll be slightly off. Like, even just the size of it will be a little bit different compared to anything else you've got before.
Or if the name only auto-populates once you've kind of approved it.
Something like that.
I have to add you as someone who's one of my contacts that comes to me an email. So instead of luke.zadkovich at floydzad.com, I get Luke Zadkovich. But if it's luke.zadkovich at floydzad.co, then I get
you get the whole thing. Yeah. Anyway, that's enough for today. Thanks again, and until next time, take care.
Thank you very much.